In this webinar, we will address the important topic of the duties and responsibilities under the rules of professional conduct of supervisory and managerial lawyers. The instructional goal of today's presentation is to educate the attendees about the main bar rules that govern the professional conduct of supervisory and managerial lawyers, how far these duties and responsibilities extend, how violations of the rules can occur, and how violations can be mitigated or prevented. While we'll be talking about the Florida Bar's rules of professional conduct, those rules are derived from the American Bar Association's model rules of professional conduct, and so much of what will be covered is applicable to the identical or nearly identical rules in other jurisdictions. For today's presentation, the attendees have been provided with copies of the Florida Bar's Standards for Imposing Lawyer Sanctions. They have also been given a recent bench memorandum on the topic of lawyer misconduct and the basic duties and responsibilities of lawyers and supervisory lawyers. The principal rules involved in today's discussion are Rule 4-3.4, Fairness to Opposing Party and Counsel, which is the equivalent of Model Rule 3.4. Rule 4-5.1, Responsibilities of Partners, Managers, and Supervisory Lawyers, which is the equivalent of Model Rule 5.1. Rule 4-5.2, Responsibilities of a Subordinate Lawyer, which is the equivalent of Model Rule 5.2. Rule 4-5.3, Responsibilities regarding non-lawyer assistance, which is the equivalent of Model Rule 5.3. And Rule 4-8.3, Reporting Professional Misconduct, which is the equivalent of Model Rule 8.3. Rule 4-3.4 sets out the basic do's and don'ts of being a lawyer. This rule prohibits sharp and dishonest practices, including hiding, altering, or fabricating evidence, disobeying valid obligations under the rules of a tribunal, abusing the discovery process, expressing personal opinions about the credibility of a witness, alluding to irrelevant or inadmissible matters, asserting personal knowledge of facts at issue or an opinion as to the justness of a cause, getting witnesses to withhold information, and threatening criminal prosecution or bar disciplinary charges to gain an advantage in a civil matter. Rule 4-5.1 describes the responsibilities of partners, managers, and supervisory lawyers. This rule requires lawyers to make reasonable efforts to prevent rule violations and to avoid or mitigate the consequences of those violations. Rule 4-5.2 makes it clear that a subordinate lawyer is bound by the rules of professional conduct even when acting at the direction of another person, and that, quote, following orders, unquote, is not an excuse for misconduct unless the lawyer is acting in accordance with a supervisory lawyer's reasonable resolution of an arguable question of professional duty. Rule 4-5.3 sets out in great detail the duties and responsibilities of non-lawyer assistants. It requires that persons using the title paralegal, legal assistant, or other similar term be supervised by a lawyer, and that supervisory lawyers ensure that non-lawyers employed, retained, or associated with a lawyer or law business entity conduct themselves in a manner compatible with the professional obligations of the supervising lawyer. The rule also establishes that the supervising lawyer is responsible for the conduct of supervised non-lawyers that would be a violation of the rules of professional conduct if committed by a lawyer, and imposes on supervisory and managerial lawyers a duty of avoidance or mitigation of consequences. The bottom line of Rule 4-5.3 is, quote, although paralegals and legal assistants may perform the duties delegated to them by the lawyer without the presence or active involvement of the lawyer must review and be responsible for the work product of the paralegals or legal assistants, unquote. Rule 4-8.3, concerning the reporting of professional misconduct, requires all lawyers to inform the bar if the lawyer knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. This rule also requires lawyers to inform the appropriate authority of judicial misconduct that raises a substantial question as to the judge's fitness for office. Rule 4-8.3 also makes it clear that disclosure is not required in certain privileged or confidential situations, and provides a limited exception for the Florida Bar's Law Practice Management Advice and Education Program. Today's panel includes two well-known and highly respected lawyers, each possessing a great depth of knowledge and experience in the area of lawyer regulation and the rules of professional conduct. Chris Altenburnt is a shareholder at Baker Lopez Gassler and a retired judge who served with great distinction for many years on Florida's 2nd District Court of Appeal. Joe Korsmeyer is a former prosecutor who served more than 8 years as a bar counsel before going into private practice, and who has more than 3 decades of experience in lawyer and other professional regulation matters. I am Bill Burgess, and I will be the moderator of this webinar. I welcome you to what will be a fascinating and very informative discussion. And now to our panel, beginning with Mr. Korsmeyer. Would you please introduce yourself?
Sure thing. Some of you know me, maybe a lot of you, but I was a Sixth Circuit prosecutor from 1986 to 1990. Then I worked for the bar from 1990 to 1998. When I left the bar, I started working in private practice, obviously, defending lawyers in bar disciplinary matters, giving ethics advice to lawyers. I call it my prophylactic therapy, helping them through and guide them. I also testify as an expert in legal malpractice claims, motions to disqualify, fee disputes. I represent all licensed professionals in the state of Florida that may have problems with their license, including getting the license in the first place, and if they have a complaint against their license. And I think that's my elevator speech. Thank you, Judge.
Okay. All right, great. And Chris?
I was on the 2nd District for a long time, and I've been out in private practice now for almost exactly 5 years. Compared to Joe, I know little to nothing about these rules, so we will rely upon him to great extent. But for the last 15 months or so, I have been representing the bar in the final stage of a contested disciplinary proceeding. These are filed in the Supreme Court as original proceedings. They assign them to a referee, and then if the parties are unhappy with the referee's recommendations of guilt and sanction, it can be reviewed by the Florida Supreme Court. It's a little bit like taking a magistrate's order to a trial judge, and a little bit like an appeal. And so they brought me in because I do the appeal part of it. So it's been very interesting.
All right, great. Well,
most of the ones I see are fairly serious ones, and so some of the things that are minor that Joe knows a whole lot about, I never get to touch from what I'm doing. So,
okay. All right, thank you. To get things started, if I may, I'd like to present a hypothetical scenario to both of you. Joan James is a licensed lawyer, just a year out of law school. She has joined the Barney Masterson American Inn of Court and is at the reception before her first meeting of the inn. During the reception, Biff Berger, a longtime member of the inn and a senior partner at a prominent law firm, strikes up a conversation with Joan. During the conversation, Biff tells Joan that he has a great paralegal working for him, Claude Cooper, who Berger employs for drafting pleadings in important cases, and that this paralegal is so good at what he does that the partner simply tells him what he wants and lets the paralegal handle it all by himself, that he never actually reads what the paralegal produces, and that he allows the paralegal to give his finished work directly to Biff's secretary, Della Dunn, who Biff has instructed to electronically file the pleadings under Biff's name, as they are not to bother Biff with having to read the pleadings for himself before they are filed. Biff also tells Joan that the managing partner of the firm, Eddie Evans, who is responsible for supervising the support staff, knows all about the arrangement between Biff and Claude and just doesn't get involved. Are there any problems with that scenario?
You want me to start?
Sure, go ahead.
Yeah, there's a lot. Biff should go back to the future But if he doesn't, what he needs to do is understand that lawyers have a very important duty to supervise non-lawyers and lawyers, of course. And the rule on point is that if this lawyer, if any lawyer does not supervise a paralegal in ensuring that documents are appropriately drafted and filed, they're going to be in some serious, have a serious issue if those documents are improper. That scenario has come up in my practice. I actually had a paralegal that I did some workers' comp in my long distance past, and my paralegal was a 30-year paralegal, and I hadn't practiced that long, and she probably could have done that for me, but I think I understood my duty at that time. So yeah, there's a rule. 4-5.3 requires lawyers to supervise the non-lawyers to make sure that documents are properly filed. And there's actually a case that I can think of that I talk about in my webinars. A lawyer in Chicago was prosecuting deadbeat students that weren't paying their student loans for the federal government and through a contract, and was filing complaints against individuals who allegedly had not paid their debts, repaid their debts. Complaints were being filed, and they had private and confidential information in the exhibits, in particular, social security numbers, phone numbers, personal information. That lawyer received a public reprimand. He admitted he mucked it up, and the reason was he wasn't supervising. So that's a problem with lawyers supervising non-lawyers. Obviously, it was a horrible situation, and actually, the lawyer was very remorseful from what I could gather from the case. So it's very important for lawyers. And in the scenario, and I'll just mention this: the scenario mentions the supervising lawyer, the partner, I should say, or the lawyer that was supervising the lawyer. Just because the lawyer knows all about it and doesn't do anything about it, doesn't make it right, and it also implicates that lawyer for failing to supervise. Because anyone that saw this scenario, I think, should realize that it's improper. So that's my quick or my comments about it.
All right, Chris, do you see any problem with that arrangement? It sounds like it's
Well, I agree with pretty much all of what he has said here. The rule actually says that the lawyer has ultimate responsibility for this person. And frankly, I have a pending case on these issues involving a partner supervising lawyers. And when you do the research on that, you actually find more cases of lawyers getting in trouble for failure to supervise paralegals and staff, in part because those people get into things like trust accounts where it becomes very serious in a big hurry. So yeah, for the lawyer who is delegating this to the paralegal and then not reviewing the work, there clearly is a problem, and that will arise when something goes south. And for the lawyer, the rule on lawyers is that the partner has to make sure that there are rules in place for compliance, and that the supervisor has to make sure that there are reasonable efforts to make sure those rules are actually carried out. And you can reasonably assume that those rules will carry over to non-lawyers in this kind of context.
What about Eddie Evans?
One other thing I would add is that it seems like there's a bigger risk. It's a rare situation, but if your paralegal is a suspended lawyer who can't practice law, and so you brought this person in as your paralegal, you still have to supervise them. And that's probably one where people tend to become very lax about it. And from what I've seen, the bar pays fairly close attention to that.
What about the managing partner, Eddie Evans? He's getting a free ride. Doesn't have to supervise the paralegal. Is that any problems?
Yeah, the rule applies to partners as well as supervising lawyers. So that Eddie's got a problem there if things blow up, and certainly we'll have to answer to that. And it's it's mentioned. Judge Altenburg mentioned the situation with the trust account. There's a case that happened a number of years ago, and it's actually happened more than once, where a lawyer gave the trust accounting to an individual who was a non-lawyer and said, "Do what you will, just make sure you do it right." And there have been embezzlement cases involving hundreds of thousands of dollars where lawyers have had to answer to the bar, and actually the one lawyer I'm thinking in particular was in Pinellas County. It happened twice, and that lawyer is ultimately disbarred. So it's a very unfortunate circumstance. So my advice to lawyers is always don't abandon your duties with regard to trust accounting, because that's certainly the one part of our practice that we must supervise, or we'll have something like that happen, and that's presumed to be disbarment if depending on the circumstances, but it's very serious if money's missing from the trust account.
What about poor Joan
Keep in
James?
mind, there's a domino effect here too, because the senior partner will say, well, I wasn't responsible for the paralegal. I wasn't the paralegal supervisor. I didn't really even know her name.
Right.
But the rule says that he has to both have in place, and since he's probably the managing partner for the lawyer who is supervising him, he has to ensure that that lawyer obeys the rules. So this is kind of a two-step process. The person that he clearly is not adequately supervising under Rule 4-5.1 is the lawyer who in turn is not supervising the paralegal. So they both have problems with this.
What about poor Joan James? She didn't ask for this this conversation. Does she have any reporting, arguably any reporting requirement under the bar rules? Joe, what do you think?
Well, our snitch rule requires 4-8.3, by the way, which we have listed in, that's affectionately called snitch rule. And everybody in my area of practice calls it that. I don't know if everybody else does, but I think they do. That requires reporting serious misconduct by a lawyer that shows that lawyer is, significantly lacking in the fitness to practice. So what I've told lawyers through the years when I've been giving them advice, because I get calls on, should I report this lawyer, relatively often. Each lawyer has to determine whether the conduct is appropriate for reporting. It's a very serious, it needs to be a very serious matter that is affecting the perception or the ability of the lawyer to practice. The easy ones are the lawyers stealing trust account money, or the lawyers committed felony crimes, or the lawyers doing this, very serious matters. This is one where it's a failure to understand the requirements of lawyers. And so whether it's not a mandatory reporting, and there's also, which everybody may know, there's no time frame, there's no statute, there's no limitations period. But I think it shows a pretty much a lack of the ability, the fitness to practice. But is it serious enough? That's what every lawyer would have to decide. But I would probably recommend that the lawyer think hard, think hard before filing a bar, or before reporting it to the bar. Maybe take other steps to try to remedy it, if possible, first, and then. But like I said, I don't know that I don't know that it rises to the level of a reporting under 4-8.3.
Hey, Chris, you agree with that?
I tend to agree with that. And the bar doesn't call it the snitch rule, but the process of doing this is a fairly serious process, and it has consequences for everybody involved. And so you at least have the time to sit back and think about this a bit. Maybe talk to your senior partner about it and say, should we talk to these people? I'm the pupil in the group. I don't feel like I'm comfortable going to this man and pointing out he's violating the rules of professional conduct. But if you got assistance from an older lawyer, you might be able to have some telephone calls that work something like this out before there was substantial harm. I mean, if he went further and started to tell you that he'd had some defaults, or that this lady was drunk on the job or something like that, it gets a whole lot harder, I think, at that point in time.
Okay.
But one thing Joe mentioned I'd emphasize is that statute of limitations, the good news, the bad news is the statute of limitations is really long, and it's a discovery statute. The bar statute is 6 years from when they discover it, and that's 6 years for them to commence the investigation, not to file the bar complaint against you. So that means you have some time to sit back and work on this, but it also means that you can get a bar complaint a long time after something went bad.
So supervisory and managerial lawyers are given their own bar rules, basically. So how do you define those types of lawyers? What makes for a managerial or a supervisory lawyer?
Um, just it's fact based, and obviously, if somebody's a named partner, they're going to, in the name, or equity partner, or name, considered to be a partner, they're going to have to answer to that. If it's if it's their partner in name, everything but name, then it'll be a factual investigation.
So if a
Supervisor.
lawyer sets up an organization and doesn't call it a law firm, calls it something else, just a co-op or something like that, and alleges that every lawyer in this co-op is independent, but let's say they have a common trust account, is that something that would make that particular lawyer a supervisory or managerial lawyer, or are there even more problems with that?
There's more problems with that, but as far as the managerial part of it, if there's a common trust account, this lawyer, whoever's responsible for a trust account, would obviously be required to answer to any problem that may be created. But I think it's as I said, it's a fact-based analysis to determine what the reality is versus what somebody's called in the context of an entity, even if it's not, obviously in Florida, it has to be a law firm has to be an authorized business entity under the rule. So that authorized business entity would be considered to be essentially a law firm. So trying to get around that would be a problem and would probably cause even more issues with the lawyer that tried to engage in that type of end around of the rules.
Okay, Chris, what do you think? You agree?
A couple things. First, a law. I think you should assume the definitions are more functional than they are technical or legal here. What are people really doing? And for example, for some purposes under these rules, a law firm is two lawyers, whether they're a PA or whether they're just in an office together. If to the public and to the client they look like a law firm, they have a good chance of becoming one. And I have a feeling that the supervisory functions may kick in under that definition. But for example, I know of several law firms where one person is the partner who holds equitable one share of stock in the business as a kind of the equitable possessor of this for everyone else. And then they give people that I would think of as partners some different name. One of them's directors, for example, but they operate like a law firm, and they probably have a trust account like a law firm, and they make decisions on salaries and clients and conflicts like a law firm. And the fact that there's only one partner in there, I don't think is going to be of any benefit to them under this rule. This rule, I think, will treat the whole thing like a normal law firm.
Can a lawyer be both managerial and supervisory at the same time?
Sure.
Yeah, absolutely. And also, just to kind of pick up on Judge Aldenberg's theme, there are firms out there that are partnerships of PAs, and those and they hold themselves out essentially as a partnership because they're a partnership of PAs. So under the that scenario, in my opinion, the bar would say, okay, you're all considered to be partners of that firm because you've partnered up as a partnership of PAs, and it's really very significant in the context of a trust account issue, because in my days as a bar prosecutor, I was required to investigate a law firm that was a partnership of PAs on trust account issues, and the lawyers that were partners, that were considered to be the partners, they were made, and it ended up not being a disciplinary, finally making disciplinary sanctions, but the analysis was that every one of the partners were responsible for the trust account. So that's important for lawyers to know.
Okay, just to dig a little bit deeper, if I may, I have another scenario for you to discuss. Abby Adams is a licensed lawyer involved in contentious litigation. She despises the opposing counsel, Zed Zander, because she has never beaten him in trial. To improve her chances of winning in the current litigation, Adams devises a plan to have Xander disqualified from the case based on her client just having told Adams that a few days before, while the client was fueling his car at a nearby gas station, he saw Xander at the next pump as Xander was getting gas for his own car. The client did tell Adams that Xander looked in the client's direction and their eyes met, but the client did not tell Adams that Xander and the client had any communication. Adams did not inquire further of her client, but with the knowledge and consent of her client, Adams instructs her paralegal to prepare a motion for disqualification, alleging that while at the gas station, Xander approached her client and improperly attempted to talk with the client about the pending litigation. Adams then goes to her supervising attorney, Benny Brewster, for approval before filing the motion. Brewster does not ask Adams if she has verified the allegations in the motion, approves the motion, and brings the motion to his supervising partner, Charlie Crispy, for final approval. Crispy does not ask Brewster about verification and approves the filing of the motion without speaking to Adams. Upon getting the motion approved, Adams instructs her secretary to electronically file the motion in the name of Brewster, quote, to give the motion more weight, unquote. Upon being served with the motion, Xander calls Brewster and tells him in no uncertain terms that the allegation of improper ex parte contact is untrue and that he is going to take the matter up with the presiding judge and with the Florida bar. What are the bar rules involved and what are the reporting requirements?
This is a law school exam, right?
I was on mute. Yes, that's a very interesting one. And Abby Adams sounds familiar, so I don't know how I know those names. But as far as the sorry, I have to plug in my laptop because it's running out of juice. Do you want me to take this or
Sure, go ahead.
So obviously Abby Adams is engaging in a fraud, and that's a problem. And certainly it is a vindictive fraud. So Abby would have some direct, sorry, I'm going to plug in here if I can. Okay, I think I'm good. All right. She would have a problem with devising a fraudulent motion to disqualify, and every lawyer has a duty to certify, and we all know this, that everything we put in our motions, everything we put in our pleadings, everything we put in every court document, and actually everything we send to someone else that is sent in good faith and is proper and is not a fraud. And this
well, what if she says, well, I just believe this to be true? So my client didn't tell me, but in my heart of hearts.
Well, we're not in national politics here. We're in legal. We're in the legal area. So yes, there has to be a factual basis for believing it, and not asking your client, whether this really happened and just assuming it happened. And it sounds like that's probably maybe an argument that Abby would make. I don't think it would cut it. And I'm the defense lawyer, so in my opinion, that would not. Of course, this is we're talking about a scenario which hopefully never will happen, but, gradations of this happen, as we all know. But there needed to be under this scenario, a lot more investigation and also, an insurance or ensuring that what is said in the motion is not false. And both Judge Altenburn and Judge Burgess, you both know this. You rely on the accuracy and you rely on the pleadings being accurate, true, and accurate. And if they're not, then justice is thwarted. So that's my opinion as far as Ms. Adams is concerned.
Okay.
And Ms. Adams is also, she transitioned to attempted to talk, which
that's setting it up.
In bar language, this is probably knowing and intentional. This is a shift to magic words that sound like a lot more than they are. And in a situation especially in disqualification, sometimes you do these things under oath or you verify it. And
client does, yeah.
That can be a serious bar violation when you do something like that.
Can her conduct get her supervising attorneys in trouble, Mr. Brewster and Mr. Crispy? They have any liability in this?
Can I say something about the motion real quick? And then the motion is obviously there has to be a supporting affidavit and supporting verification. So if that client's lying, then what this attorney is doing is supporting perjury. So I'll just leave it at that.
Yeah, although this client didn't lie to her. This client said he just looked me in the eye. So you either have to get the client to commit perjury that you know that is taking place, or you
Reporting
have
it.
some other problem. Yeah.
100%. And so that was my comment on that. But yes, supervising lawyers have a duty to do more than, and of course partners too, but supervising lawyers.
Well,
have
they
a duty.
believed her. She came in and said, "Hey, here's a good motion, and it's all good." And do I look like I'm lying to you? Or, she just was very convincing. I need you to sign. Actually, probably done very routinely. Can you okay this?
I get it.
So, Joe, has that ever happened in your experience?
Yeah, I mean, with that lack of knowledge and the factual scenario, or the question would be whether that lawyer should have delved into it more, and that's always going to be an issue if a lawyer says, I didn't know about this, and how can you but there is, as we know, and we're talking about today, the requirement to supervise, and that could potentially require that supervising lawyer to get a little, to actually supervise and talk to the lawyer to determine whether, I mean, this is obviously a very well drafted Judge Burgess scenario, but it's kind of wild, and hopefully it doesn't happen in that way. But there are gradations of that, as I've said. So yes, I think that supervising lawyers should be very careful to make sure that if they're going to supervise a lawyer, that they ensure that they are actually supervising. So that's my thought on that.
So what if Brewster? Go ahead.
If I could jump in on that too, as a supervising lawyer, depends a little bit what you're supervising. And this isn't a motion to dismiss for failure to state a cause of action. This is a motion to disqualify. And normally before you file one of those, you sit down and talk to some people for more than 5 minutes about doing this, because the ramifications are big on something like this. And then I would want to know more facts from you. Does Brewster know that she hates this guy, that she's always lost to this guy?
Well, that was the next variation. Brewster knows she hates Xander, and she actually says to him, none of this is true, and but I want to get him off the case. And Brewster goes, yeah, I'm with you on that, because I also hate him. So does Brewster get into any trouble?
It doesn't make any difference whether he's a supervising attorney, because at that point it's no longer a failure to supervise, because he is directly involved in the decision to do this. He's got personal exposure. This is not vicarious liability he has for her as a supervisor. It has to be his own negligence as a supervisor. But you just crossed him over into being something more than a supervisor.
And under the rule, if a lawyer knows, or whenever if the lawyer ratifies the bad conduct, which in this case would say, yeah, go ahead and file the motion to disqualify because I hate the guy too, that's a problem. And also there is an opportunity to say, no, we're not going to do this. So yes, I think under that scenario, 100%, I agree with Judge Aldenburn that puts that lawyer in the direct line of fire if it's proven. Obviously, we're talking about facts that have to be proven, and if the lawyer's actually participating in it, which is what that would be.
Okay, now the rules that address supervisory and managerial lawyers speak in terms of law firm. Are government law offices also under those rules?
So you want me to take this, Judge Altman? I don't mean to jump in. Yes, they're 100%. They're it's the same public defender's office. And actually, I think that the state attorneys and the prosecutors are now becoming more cognizant of that it is in essence a law firm, and you have senior lawyers. When I was at the state attorney's office, you have lead trial attorneys. Then you have the rank and file underneath, but then you have the supervising layer of bureaucracy, I'll call it, that supervise the supervisors. And everybody in that chain is responsible, to the extent necessary to supervise.
There's no prosecutorial immunity or defense privilege or any of that.
When I was there, let me just say this real quick, and you hold your thought. We used to put in, and I never got a bar complaint. When the bar complaint was filed, there would be a paragraph saying we are constitutional officers and we believe we aren't under the under the the Florida bar rules, which was not true because we were appointed by the constitutional officer. So I think they stopped putting that information in there. But the state attorney is a constitutional officer and cannot be prosecuted while they are he or she is a constitutional officer. Every other assistant is subject to prosecution. Sorry, Judge Altenburg, go ahead.
No, and what I was going to point out is that 4-3.8 creates even special duties now for prosecutors. So there are things that they can be charged with that a lawyer in private practice cannot be charged with.
Right. Absolutely.
The biggest one probably is the failure to disclose Brady information, which is treated as a big deal. And there have been some prosecutors that got pretty big sanctions for Brady violations.
And some were prosecuted criminally for intentionally doing it, right?
Yeah.
Across the board,
I don't know the answer to this, but is the U.S. Attorney's Office a law firm for these purposes? I think.
Well,
this, right?
Well, the interesting thing about that is they are from all over the country.
They don't have to be licensed in the state of Florida to prosecute here.
So that lawyer will be subject to the rules in which in the jurisdiction in which that lawyer is admitted. So if a lawyer, for instance, there was a case in Florida where the lawyer was admitted in Michigan who was prosecuted by the Michigan bar. So that's how that would work. But you're right about the supervisory. It's a choice of law or a choice of rules in this case as to how the rule would be applied. I think based on the lawyers where they were admitted to practice or where they are admitted to practice.
How far does the duty extend? For instance, if let's say a supervisory attorney tells he's working on a big case with a lawyer he supervises, and there's also somebody who is manufacturing an exhibit, say, of some kind. Is that person also, is he responsible for supervising that person as well? I'm talking about contractors, subcontractors, investigators, secretaries, all that. Is that the rule apply? If you're supervising someone, does that duty extend to everybody?
If you're farming out things that would have otherwise been done in your law firm by paralegals, it's basically treated the same way.
So. Right. I 100% agree. Investigators, lawyers are subject to, there are cases out there that you can find that are high profile where a lawyer failed to, or told an investigator, go violate the law, and were disbarred. So anytime that there's that relationship. Yes.
You may know the answer to this, but law firms that use contract lawyers or quote unquote independent contractor lawyers to do things, I think they still have the same supervisory obligations for these people.
And contract non-lawyers, Judge, like paralegals that may work off-site that do individual jobs. They're responsible. Lawyers are responsible for supervising those paralegals and ensuring there's no conflict of interest, no violation of the confidentiality rule, and those types of things.
I'd comment that in the era of COVID, I think complying with these rules just got a layer harder because I've got people in my appellate department that I review their work, but I haven't seen their face in 13 months.
It's crazy.
So how about something a little bit more benign, less sinister? A law firm contracts out to a process server to serve people for with their pleadings and all that, and complaints included. And there's one of the supervisory attorneys in the organization is responsible for that, and he never checks on the process server. And as it turns out, the process server has not been serving people properly under the law. Is that attorney possibly subject to a bar complaint for failure to supervise? Joe, what do you think?
Under the rule, yes. If the lawyer and it is, it gets a little more interesting as far as fact-based analysis. But as far as the lawyer is concerned, if the lawyer's supervising non-lawyers or hiring non-lawyers or contracting out with non-lawyers, they're responsible for, and there is a knowledge, aspect to it. If the lawyer knows this is going on, obviously that implicates it. But if the lawyer doesn't know it's going on, the rule says if the lawyer has no knowledge, then the rule kicks in when the lawyer finds out about it. and if they don't take action at that point, reasonable remedial action, and as long as they don't ratify it, if they're taking action, then that would help with regard to the rule, and most likely insulate the lawyer if the lawyer took sufficient action to correct that issue and the problem that you mentioned, Judge.
You're talking about remedial action. There's a duty once you find out that there's a problem. The supervisory attorney has a duty to take reasonable remedial action. Is that what you're saying?
Yes, sir.
Okay. And so if what if the lawyer knows about the process server and just says, oh, well, that's nothing I can do about that. Is that lawyer, can the lawyer plead ignorance? I didn't know, didn't find out until the bar came knocking.
Of course, the reasonable remedial action would be subject to what would be the thing that the lawyer could do. But yes, the lawyer would be responsible for failing to take action if, in fact, the lawyer could take action to correct it. Now, if it's firing the process server, and if there are crimes committed, reporting them or somehow, doing something like that, yes. But yes, once the lawyer learns of the issue of the violation by the individual who is being employed or contracted out, yes, that the lawyer becomes responsible for the remedial action, in my opinion.
A side issue, and I wonder what Joe's thoughts are on this, but if you have a lawyer or especially a paralegal or a secretary who's also a notary, and they're notarizing things under circumstances where they're really violating the law on the use of a notary seal. I'm assuming that all of these things kick in for that as well.
I've handled cases involving improper notarization, and lawyers have been prosecuted by the Florida Bar for allowing that to happen, or actually instructing. In one case, I went to the Supreme Court on oral argument involving a lawyer who was involved in a divorce with the wife, and at that time there was a signature that was notarized where it hadn't been signed in the notary's presence. The lawyer ended up being disciplined, but the initial I got in late, and I went and argued, and the lawyer got a non-rehabilitative suspension. Originally, the recommendation was disbarment, but that's an issue, and certainly lawyers, and you touched on something, Judge, that's very important. The notarization law is what it is. I hate using that term, but lawyers need to know, because it's a legal requirement, and documents are being notarized improperly. It's a felony now. It's a felony. And so if the lawyer's saying, go ahead and do it, or not paying attention, the lawyer could be involved in a potential, not doing something about a felony being convicted. So it's very important. For instance, a lawyer should not send interrogatory, the signature page to the client and say, hey, please sign this and give it back to us. We'll fill it all out for you, and we'll have it notarized. That's a crime. I mean, I know we have the electronic signing now, which may make it a little easier, and I don't know enough about it. I probably know enough to be dangerous, but the old-fashioned notarization has to be in the presence, signed in the presence of the notary, and every notary would hopefully know that, because it's taught, when they get the notary seal. So that's my thought on that.
Judge Burgess, I'm curious about the aspect of this problem that deals with the younger lawyer telling her secretary or paralegal to put on the form before it's filed that it's been signed by the senior partner.
It's false, right? I mean, yeah. So we've got essentially a false statement being made that again it affects the proper administration of justice. I mean, we all should remember, as lawyers, our job as a profession is to make sure that to the extent possible, and nothing's perfect, and we all know what really goes on in the real world, but make sure that it's a fair playing field and that there isn't any cheating. So that's my comment on that.
Okay. Just to shift focus a little bit, what about when it comes to client confidences and supervisory lawyers? Can loose lips sink ships when it comes to that? Joe, what do you think?
100%. As far as confidentiality is concerned, pillow talk is not allowed. Although if your spouse works for your firm, you're probably going to be okay. But as far as, or your significant other, I guess, well, maybe not, but whatever. I think the rule would cover a significant other. But as far as confidentiality is concerned, it's one of the highest requirements of lawyers. I mean, besides don't steal trust account money, because people come to us as lawyers and they expect us to hold if we want them to give us the information we need to represent them and be accurate about it and be honest and truthful, we need to learn everything and we need to understand that we need to protect it. So, going to Starbucks and talking on the phone with a client or about a client matter is not appropriate. If there are other people around, going and setting up the laptop in Starbucks and using a public Wi-Fi, all of that is hugely important. So yes, confidentiality to me, and I do this for a living. I defend lawyers and I look at the bar rules, and I'm kind of a rule nerd. But to me, confidentiality is really extremely important, and lawyers should be well aware of the fact that it is an important part of our profession.
What if it's a subcontractor who's doing all the talking, spreading confidential information, confidential client information? Is that part of the supervisory lawyer's responsibility to make sure that doesn't happen, or to at least put things in place to prevent that from happening?
You just got it right there with the second part of your question. The lawyer can only do what the lawyer can do. And when I talk to lawyers and when I do webinars and when I talk, do seminars, the lawyer should take steps to hopefully ensure. I mean, not every person that's associated with the law firm is going to understand the importance of confidentiality, because that's not their bailiwick. So lawyers should be attempting to make sure that there's a very clear understanding that confidentiality must be kept. One example would be some lawyers that send billings to. I teach a paralegal class, paralegal ethics, and one of my students actually worked for an offsite billing company, and all that confidential information is being sent there because they're typing up the bills, right? And the question was, well, are we supposed to keep confidentiality, everything confidential? I said, 100%. Did the law firm not, or do they not tell you that? And she goes, well, there's not a whole lot of discussion about that. And I said, well, you may want to, sit down with your supervisor and say, maybe we should have something, set out in whatever the guidelines are, because, they're typing everything up and they may get something juicy, of course. And so that's a real concern.
I've got a question.
The supervisor has an obligation to do reasonable efforts to ensure compliance with this. And for example, I'll give you two examples. One's fun and one's sort of normal. Our law firm at least twice a year sends out an email to everybody reminding them that conversations on the elevator are not confidential.
That's right.
Because lawyers get in, you're talking about a case, they keep talking about it, and they don't notice that somebody else is in the elevator.
And they'll go down to lunch during a lunch break, and they'll be blah, blah, blah about it, and everybody else can hear them. You remember the Washington, D.C., the incident in D.C. where the lawyers were talking about something to do with President Trump's defense and one of the legal things that he was involved with. And they were sitting outside in a cafe setting, and there was a New York Times reporter right across from them. Of course, they didn't know it was the New York Times. There were some pretty prominent lawyers, and they were talking all about their defense of the president and what they're going to do, and talking about their strategy. And they're sitting outside, and little do they know, and of course, it doesn't matter that it was a New York Times report, except for how embarrassing it was because it got published. But that was a pretty big deal. And of course, those lawyers, being the high-powered, probably $2,000 an hour lawyers they were, I was a little disappointed they weren't aware of their obligations as lawyers. So
45 years ago, before there were inns of court, Joe must be too young to remember this, but there was a place downtown called the Quick Red Fox. And, right after work, plaintiffs lawyers and defense lawyers, we all went to the Quick Red Fox, and we had too many drinks and we talked to one another. And
you walked home.
And then of course you walked home. And, when my law firm moved into a new building in 1980, Bob Banker and I intentionally put a bar in our law firm because not only was it good for camaraderie, but it allowed us to be able to control conversations that should remain confidential. And frankly, Also allowed us to make sure that people were far less likely to drink too much if they were drinking in a bar in the office than they were in a bar. And 40 years later, it's still there. In fact, it is now in what was Morris White's office, and I think he would like that fact.
That is great.
Would that qualify
That's
as
great.
a remedial measure?
I think so. I mean,
Yeah,
to some degree it was, because that's intentionally why we did this.
And you can call a taxi, call them a cab if somebody's that way, and you don't just jump in their car and drive away.
Okay,
That's
I have
awesome.
a question from the floor for you guys from Suzanne Kishan, and her question is, let's see, what about paralegals interacting with other lawyers? So are there any special limits on that?
The paralegal is an agent of the lawyer in the law firm.
Yep, I would just rephrase the question as how much trouble can be caused by a paralegal talking to another lawyer about business that the paralegal was involved in? To a lawyer that's not involved in that.
Right, there could be huge implications in it, and whether the paralegal will be fired, confidential information is being provided to another lawyer, then that would implicate confidentiality with regard to the lawyer who is supervising that paralegal. So yes, the interaction, paralegals are just as responsible for maintaining confidentiality of matters and information as lawyers, just as much.
So do supervisory lawyers have a de facto obligation under the rules to advise those they supervise about keeping client confidences, that is to keep confidential information confidential? And if they fail to do that, can that be used as an indicator of failure to supervise?
The rule requires the lawyer to take take reasonable measures to ensure that the bar rules are complied with. When I talk to lawyers, when I lecture, I tell everybody, and maybe somebody that's here might know that I've said this. It doesn't hurt to provide copies of the most important bar rules to staff when they're first hired and say, please review these rules. They're very important for you to know. And then maybe even have a discussion about them, including confidentiality, conflict of interest, and then sign off on, yes, I did review all of these rules and I understand my obligations, could be even 4-5.1 and in the rules related to supervising, showing that the pass-through, and then that to me would certainly, if the bar came knocking, they would have that document to show, hey, I did that is how those are the measures I took, or that's the measure I took to try to make sure that the bar rules were adhered to.
Hey, Chris, what do you think?
I mean, the paralegal isn't necessarily directly governed by these rules, or himself or herself, but when they're working for you and you have ultimate responsibility for what they're doing, you pretty much have ultimate responsibility to make sure that they're not vicariously violating for you what is your own rules. So
the duty is really not, it's not vicarious liability in terms of transferring the actions of the supervised employee. It's the duty to supervise that is the focus of the bar when they look at violations.
And this is a dual layer thing. We're talking about professional responsibility, but right underneath it or right above it is malpractice. And if you have a paralegal that starts revealing confidentiality, she's your employee and you're responsible vicariously or responding superior for that. And so you may not get disbarred for it, but you may have to pay a malpractice judgment if you're not careful.
Now, isn't there also part of that understood that that supervising attorneys have an obligation to protect their employees against being exposed to civil liability for instance, for not knowingly, but not knowing it's confidential information, but divulging information or committing other actions that would be considered torts? Joe, what do you think?
I think that would be the principal agency theory in practice. There is that pass-through when there's an employee, and lawyers need to be fully aware of the fact that there is that pass-through. But also, if a instance, a paralegal goes and solicits a client, goes to the accident scene for a personal injury lawyer and says, you should let our firm represent you, and solicit improperly. The lawyer didn't take, steps to prevent that from happening or knows about it, then that lawyer's going to be responsible for the violation of that rule, as well as the failure to supervise. So lawyers should be aware of that. There can be a pass-through for a violation of the rules. Now, does it happen very often? No. But lawyers need to be, we all need to be fully aware of that.
Okay, let's see. We have another a question here. If the paralegal is an FRP, does that FRP have his or her own obligation? And if so, to what extent does that exonerate, or does it the supervisory attorney? It's a compound question, but you guys have been in law school, so you'll be able to handle that rather deftly.
The Florida registered paralegals are still paralegals, so the same rules apply. It doesn't matter whether a paralegal is an FRP. It does have a heightened requirement for that FRP to comply because they have voluntarily become an FRP and are responsible for their conduct under the FRP rules. But since that's a voluntary, paralegals voluntarily become registered paralegals. They might lose their registered paralegal designation, but also there's still that pass through, and all the other rules apply, with regard to supervision and compliance with the bar rules.
Okay.
I would say that as even with lawyers, the more competent and experienced a lawyer is, probably the more you can trust them, and the supervisory obligations go down a bit as they become more competent. And the fact that you've got somebody who's become an FRP and all of that might at least be a justification for you to say that you thought they knew what they were doing, and it came as a surprise to you. But
I 100% agree, because that heightened competence would I think the reason that we have that program is that there would be heightened competency and more of a, and so lawyers would be entitled to rely on that. But of course, the same rule would apply if the lawyer knew about it and failed to take action or ordered that FRP to do it. So I agree 100% with you, Judge Aldenburn. That's a good point. It's a good point.
What if a lawyer is dealing with an opposing counsel through the other counsel's paralegal, and that paralegal is engaging in questionable behavior, troublesome behavior? Is that because the lawyer only suspects that the paralegal is acting on behalf of the other counsel? Does that preclude the lawyer who's being troubled from reporting that to the bar, or is there something else the bar would recognize as appropriate for that lawyer to do?
Wow. So if the
our audience is paying attention. They're asking.
Yeah. If the paralegal is acting badly, then go to the lawyer who's supposed to be supervising the paralegal, and if they fail to take action, it depends on how serious the conduct was with regard to the paralegal as to whether there'd be any reporting requirement. Maybe if it's something extremely serious and the lawyer refuses or fails or refuses to take action, and it still continues. But I don't know that would actually be something that the lawyer should be thinking about doing under that circumstance, unless it's extremely egregious. That's my thought.
You ought to have a structure in your law firm, if it's of any size, that you do have a managing group of lawyers who meet as a board or whatever, and the ability to first go to a board like that to try to address whatever troublesome might mean seems like a better idea.
All right. So how serious does the bar take these things, in your experience? What do they do when they're confronted with a lawyer who either fails to manage or fails to supervise in a very serious way?
Well, there aren't a whole lot of cases that go to the bar involving that. I would tell you that, based on my anecdotal experience with them, and based on the there's not a lot of case law. But the bar takes seriously matters that show that there are serious misconduct. And if there's misconduct, they do investigate it. So, as we all, let me just mention this. There are multiple layers of investigation. The Florida Bar takes in a case typically through their what they call the ACAP, which is Attorney Consumer Assistance Program. That lawyer investigates it initially and determines whether to move it forward. And then if it goes to the local office, then that attorney can send it to the grievance committee. And then if there's a finding of probable cause, unless there's a emergency, a reason to file emergency sanctions or former emergency suspension. So depending on the situation, I wouldn't want to make a blanket statement as to what the bar would do, but especially in the context of professionalism and other matters, the Supreme Court of Florida is taking matters very seriously involving lawyers. And so really more directly the lawyer's conduct. But I would think that the fact that the bar counsel are considering matters much more seriously and much more taking their cue from the Supreme Court of Florida would consider matters to be much more conducive to an investigation and finding out exactly what happened, maybe possibly than in the past. I don't want to disparage anyone who worked before, but I think I'll leave it at that. That's what I see right now with regard to the Supreme Court.
Chris, can a lawyer actually be suspended from the bar for failure to supervise?
I really probably can't discuss it to any extent, but I can tell you that there's a pending case that began with an emergency suspension of a lawyer for failure to supervise, and the bar is taking that case very, very seriously. But keep in mind that you may not be looking at a 91-day suspension or something like that for one of these things, but the chances that somebody who's managerial or supervisory could at least get an admonishment for these kinds of things, I think that there's probably lots of room for that right now.
And during the recession, during the real estate recession crisis in the 07-08 timeframe in 09, there were multiple lawyers, and they actually created a task force in Orlando for lawyers who were being prosecuted for failing to supervise what the individuals who were essentially entrepreneurs that were using their name essentially to send nasty letters out on loan modifications and those types of matters. And I represented some of those lawyers, and one of my clients received a 91-day suspension. And it was purely for failing to supervise. Now, there were some other issues where the lawyer had signed a letter that was filed that had sent to Michigan in a Michigan matter. So there was some UPL, some other issues, but the bar took those very seriously, and that's an example of where that happened. So depending on the circumstances, Judge Aldenburn's correct. You got to look at the facts to determine what should ultimately happen. But if it comes to the bar's attention, they are my understanding is, my experience is that they're going to investigate it.
It's worth a couple comments here. For lawyers who might not know the intricacies of this, a 90-day suspension, you automatically get back in on day 91. The 91-day suspension is not a 91-day suspension. You have to reapply and go through steps, and you may or may not make it on your reapplication. So it's basically being suspended probably a year and a half for most people that have this happen to them. So that's a big deal. But and likewise, over the last beginning maybe 15 years ago, the Supreme Court started saying they were going to sanction more. And it seems to me that in the last 10 years, progressively, they're sanctioning even more for things. So things that used to be minor, it's not so easy to tell you today that they would be minor in the same way that they would have been 30 years ago.
Now, what's the effect of a judge complaining about a supervisory attorney? Does that add fuel to the fire, Joe?
Yeah, well, the bar's policy is to prioritize complaints that are filed by judges, and they consider them very seriously, and they take them. They actually have a policy now where there are certain matters. There's rules pending before the Supreme Court of Florida that would require the bar to keep the judge informed, and it does. It 100% is a more heightened scrutiny when a judge. There's a couple ways to do it. One is the judge could file complaint, usually it's an order. The judge sends the bar that had findings in them that the bar will investigate and prosecute. So yes, a judge made complaint and it's been that way since I've been doing this. Back in '90, it's considered to be now. Whether they would do something different ultimately, I don't know. I mean, obviously, a judge is a lawyer, and we should take judge's findings and possibly complaints seriously. But yeah, I think it does, as you said, add fuel to the fire.
Okay. Judge Burgess, the Rule 4-3.4 is the rule on fairness to opposing parties and counsel. And that's a rule that has gotten increasing teeth inside it over the life of the rules of professional conduct. And my sense is that the Supreme Court is taking that rule more seriously, as are trial judges. And so while the lawyers may complain about this because of motions for protective order and other discovery fights that go on in front of circuit court judges, they're beginning to see misconduct that's outside the courtroom and depositions and the like. And these are issues that, if reported by a judge to the bar, I'm pretty confident that they will take quite seriously. And there's probably much greater willingness to impose greater sanctions for these in the past. And if you're in a law firm and you're the managing partner or supervisor and you know your lawyer is violating these things, I think there's an increased risk that you can have problems with this.
And I'll just make a comment, if I could. Judges are not required to. Judges are subject to the same 4-8.3 rule. Judges can take care of errant lawyers by imposing sanctions. Judges have an inherent authority to impose sanctions on lawyers that act badly to supervise their courtrooms. So there's no requirement that a judge report what could misconduct during litigation unless it's serious enough that it requires a report. And that there is that. It's gone back and forth. I've done seminars where judges participated, and the bar doesn't do enough, and then the bar will say out loud that the judges should do it on their end. So there's that push and pull between the judge's inherent authority to impose sanctions if the judge behaves badly. But there's not necessarily a requirement that it's an automatic report to the Florida bar. Now, there's nothing that's going to stop. The judge can report something but that kind of doubles it, because if the judge imposes sanctions, then the bar is going to look at sanctions too. So
the judge can impose sanctions and then refer the matter to the bar, and the bar can take its turn at imposing sanctions.
That's what would happen. If the judge reports it, then the bar will investigate.
Okay. Appellate courts are kinder, gentler places than trial courts for lots of different reasons. And I can tell you that in 27 years, I never reported someone for misconduct that was in the nature of being, obstructive to the court or to opposing counsel. We generally were able to take care of that on our own.
But you did testify in a bar case where I was the prosecutor, if you recall, involving a lawyer that happened to be from Pinellas County, right, Judge? Not to interrupt you, but that was I had you and a couple other.
This was David, whatever.
Yeah.
Okay.
Yeah. You're one of my 3 appellate judges, and I had like 4 or 5 circuit judges.
And I have testified in 2 or 3 of these things over the years.
But you didn't report that.
This is a good example of. I actually reported this person he's talking about, not because I was concerned that he was disobedient to the court, but I thought he was a danger to his clients. He had some what I thought might be mental issues going on, and as a result, he was doing strange things, and we reported that.
And the court ultimately, as you know, Judge, said that the attorney had to obtain a mental evaluation and would have to be found to be fit before that lawyer could come back into practice.
If I recall, they split 4-3 on that, as a matter of fact.
I remember. Yeah, that was my case, so I remember that well. It's a published case, and I was interested to see. And I know that there was a dissent. I forget who the justice was that dissented. But yeah, you're right. And really, it was mostly, if you remember, a competence issue where there were problems with filing the initial appeal and not found the filing fee and deficient affidavits. And I'll just say this: competence cases involving lawyers don't typically rise to the level of what this lawyer received, which was 91 days, which is, as you said, Judge. And Judge, that lawyer's was never reinstated. That lawyer never became a lawyer again.
Yeah.
Maybe the terms from out. Yeah, I don't know. But competence is usually going to be at least a very serious showing of a lack of competence or multiple instances of misconduct. Lack of competence, which is what happened in that case.
Do the supervisory rules apply to judges who supervise judicial assistants, or judges who are in the administrative portion of the judiciary who have supervisory authority directly or indirectly over their staff, their lawyers, their so on and so forth? Joe, what do you think?
Not under the bar rules, because the bar rules don't apply to judges unless and until they become ordinary lawyers again, like Judge Altenburn has. but as far as the judicial canons, they would apply, and to the extent that they would be applicable for any conduct involving a judge, that's where the investigation would happen, in my opinion.
So the basic the spirit of the rule would be brought into the canons purview. So
you can get a JQC complaint for not adequately supervising staff attorneys and things like that. Yes,
okay, so that's so as important as we think we are, we still have to properly supervise people we're assigned to supervise. All right, well that sounds very fair. Now, what's the most common problem that a supervisory or managerial problem has with the bar? If you could name the 2 or 3 things that most often, the mistakes that are made, what would Joe or Chris, what would you think in your experience they would be?
The litigation, supervising lawyers and or partners that don't understand how important it is to supervise young lawyers and mentor them. I think that one of the things I've seen is we've kind of gone away a little bit from maybe if we ever had it, the mentoring process. And a lot of lawyers are going out on their own and not having that mentoring process. So they're not learning. I mean, sometimes they're learning it from me when they're defending a bar complaint, which is very unfortunate if they've gone out on their own. So, and I do that all the time, give advice and counseling, not only in bar cases, as I said, but in ethics, giving advice. But I see that happening more in litigation, because litigation is inherently more adversarial. It is adversarial, and there is that push and pull between, whether it be criminal litigation, criminal defense, or civil litigation. I see it more there, and I think that's what I see the most is now, whether it's true or not that there's a lack of supervision, I see that as being something that lawyers are not necessarily don't understand how important it is to supervise, especially young lawyers.
Hey, Chris, what do you think?
So I don't know that I've got an adequate sample to be able to tell you, what the most common things are. But that in the case that's pending right now, one of the things that got the bar's attention was that the associates were getting a lot of sanction orders and Cozell orders and things like that, and the law firm wasn't seemingly doing much about that, and that definitely got the bar's attention to the point where they got an emergency suspension. So
that's probably what was in my mind, Judge, when I was mentioning that, because I'm familiar with that case.
Yeah, sure.
Now, what about a situation we have a legal organization that has a member who has a substance abuse problem? Let's make that, for simplicity's sake, let's make that person a lawyer. There's a supervisory lawyer who knows that person has a drug or alcohol abuse problem, but when the person's sober, they do great work, so they don't want to do anything, and they don't report anything to the bar. Is that a problem, Joe?
As long as the lawyer's not engaging in crimes or anything that would be considered to be serious misconduct, and if the lawyer's doing their jobs, other than the fact that it's going to all fall apart, maybe if they're an alcoholic and they're going to be deteriorating in their health, And that should cause the lawyer to be concerned and take action. As far as the 4-8.3 is concerned, unless that happens, what the serious misconduct and or the crimes being committed or the DUIs, I don't know that there'd be any duty to report.
So they're not obligated to be compassionate. They're obligated to be practical, and they should be compassionate. But the bar doesn't require that they report somebody who is having problems and is otherwise harmless.
I'm sorry to interrupt you, but there is the voluntary requiring the lawyer to report themselves to Florida Lawyers Assistance, Inc. and say, you must go get an evaluation and you must comply with that evaluation or other means. That's essentially a confidential reporting. And the lawyer, the supervising lawyer or partner could say, you must do that in order to continue to be employed here.
Right.
So that I think would be a reporting that is not really the reporting under the snitch rule.
Okay, Chris, what do you think about that?
I'm sorry, I got distracted by a question in the chat.
Okay, all right,
they have a question on trust accounts that Joe needs to answer because they really want to know the answer.
Okay,
on this.
we'll do that. And I think Claudia is going to come in here and make an announcement in a few minutes because we're right up at the end of our time slot here. So Claudia, if you're listening, you need to come on in and you can use the microphone here. But Chris, what do you think? What's the issue that we need to bring up at this point?
I think I'd like to talk or have Joe talk a little bit more about self-reporting because there aren't that many things where you're truly obligated to self-report, but sometimes it's probably in your best interest to self-report. And so I'd like Joe's take on it first, and then I'd add comments to that.
Yeah, sure thing. And as far as partnership of PAs, yes, every partner would be every PA would be effectively a partner. And I think that if it's a single trust account, every one of those PAs would be responsible. That's my very short answer, but there's a lot more to it. As far as the reporting requirement, if lawyers want to make sure that they are not vulnerable to a failure to report, Judge, and that's what I think what you're getting at.
Yeah.
If there's serious enough misconduct, and that now there aren't a lot of prosecutions of lawyers for failing to report. It's essentially minuscule, but if it's a serious matter that turns into something that's extremely serious and it could have been caught potentially by a reporting, then I think that's where lawyers should be very careful to examine whether they should report or not. And none of us want to report another lawyer to the Florida bar. None of us. I mean, unless we have I hope none of us will. So the question is going to be whether this is spiraling out of control. That's going to cause, some serious consequences to clients, to society. Then the lawyer should consider whether, hey, we got to stop this now. We need to report this. And lawyers can actually report another lawyer to FLA Inc. and say, please investigate them. And they will contact that lawyer and say, hey, you've been reported anonymously. Will you participate? Will you get an evaluation? And so that's a way to do it too, anonymously, even if it involves that type of serious misconduct.
Yeah, the rules on self-reporting are not all that well, they're not laid out in the rules all that clearly. And so for example, other than something like I got convicted of a felony, you may not have to self-report an awful lot of things. But on the other hand, it does three things for you. And number one, it puts the bar on notice of something they need to investigate. So at least you get your 6 years running on this thing by telling them up front. Secondly, I mean, this is one of those environments where if you come in and say, I screwed up and I'm sorry, I made this mistake and I want to make it right, the likelihood that they're going to go for the biggest penalty seems you're much more likely to be able to work it out if you self-report and show from right up front that you have remorse about what you did. And then finally, if it goes all the way and you get to me and you're not showing much remorse and you didn't self-report, I mean, that's a big story I get to tell the Supreme Court about, is this person had all these opportunities to tell people about it and didn't.
Right, right. The arrest for a felony is a required reporting. after the arrest, within
Yeah.
10 days, I think it is.
Yeah.
A conviction of both of a misdemeanor is required to be reported within 10 days of the judgment of guilt. So if we're talking about self-reporting, that's required. Okay, that's not even a question. But you're right, Judge, as far as other matters are concerned, and I've had clients call me and say, well, first of all, we have to report shortages in our trust account now. But before that, should a lawyer report an erroneous shortage, I would say you're not required to do that in the rules if you're complying with the trust account rules. So every case is different. But if a lawyer screws up and it's not something that requires a self-reporting, maybe the lawyer should consider. And really, the bar doesn't like self-reporting when it's not required too much, because it's not really the usual course of events. But if the lawyer feels sufficiently feels like it'd be important to report it, the lawyer certainly could do that himself or herself.
By the way, not to plug him, but the one person who doesn't have to use the snitch rule is Joe, because if you call up Joe, he's your lawyer. He's giving you advice, and the rule on confidentiality for 99% of all of this says Joe doesn't have to turn you in. If you're in a larger law firm and you have someone designated as general counsel, they probably fit that same category, by the way.
It's funny you mentioned that, because the rule says that lawyers can consult with me for like an opinion and do all that stuff. But I don't know if I'm 100% in agreement. If I'm told it's confidential, so I would have to err on the side of it would have to stay confidential, versus making me report something where the person's trying to get help, essentially, by calling me. So I think I would err on the side of not having to report that. But I haven't had anything that's been close enough to where. But I think that's the way that rule would come down.
Okay, we're at the end here, and I just want to pose this to both of you: is the consensus that the best protection for supervisory and managerial attorneys to have effective mentoring and good policies and procedures that are understood and followed by everybody that they supervise?
100%, I agree with you, Judge. That's the way to approach it, is with your eyes open and not with your eyes closed, and not necessarily intentionally closed, but just we all should be aware of that. And I always tell everybody, I'm not trying to scare anybody when I talk about these things. I know we're not, but it's important to know these things and realize that there are rules out there, and that's why it's important. We're doing this, Judge, and it's great that you're putting this on. By the way, you've done this has been great, and hopefully everyone's gotten good information, enjoyed it. But that, to me, that's a great and a succinct summary of what we've talked about today.
Not just mentoring, but trying to have a firm culture where the rules are not a burden, but they're something that is there to make our profession work better and the system be stronger, so that there are incentives for those young lawyers to actually learn from the mentoring and do what it is we hope that they will do under the rules of professional conduct.
I want to thank you both. We do have to end. It's 6:51 now, and I know you've got a very important matter tomorrow, Joe, that you got to take care of, and Chris, you've always got important matters to take care of every day. So we will take down the questions, and those who have haven't had the questions answered, we will follow up subsequently. I want to thank you both. I thoroughly enjoyed it. I hope everybody else.
It's been a pleasure being here. Fun.
All right, thanks, guys. You have a good evening.
What Judge Aldenburn said. Y'all have a great evening.
All right,
Take care.
Okay.
Bye-bye.